Procedural sequence. The normal procedural sequence in a family law case is as follows. 1. Normally there will be one hearing to obtain temporary orders in the case. 2. Normally the court will not take oral testimony of the parties at this initial hearing. And 3. Months after you and your spouse have filed for divorce, if you have not settled, the judge will schedule you for a trial. Normally, shortly before the family law judge grants a trial date, the judge will send the parties to a mandatory settlement conference to see if the parties can reach an agreement known as a mandatory settlement conference. Sometimes the parties can settle most of the issues at the mandatory settlement conference, and only the unresolved issues are set for trial. The trial setting. Most civil and criminal cases are tried before a jury. However, a family law case is tried before a family law judge, not a jury. In the courtroom, you and your ex will sit with your respective attorney at tables designated for the petitioner and the respondent. If you are not represented by an attorney, you will be sitting at your respective table by yourself. Basic sequence of a trial. The basic sequence of a trial is as follows. 1. Opening statements. 2. Petitioner puts on his or her case. 3. Cross-examination, redirect, recross-examination of petitioner's witnesses. 4. Respondent puts on his or her case. 5. Cross-examination, redirect, recross-examination of respondent's witnesses. 6. Rebuttal. 7. Closing arguments by both sides. And 8. The ruling by the judge. Opening statement. Each party or their attorney makes an initial statement to the family law judge about what he or she will prove during the trial. Basically, the opening statement sets the stage for what evidence will be presented and what the evidence will show. The petitioner or the petitioner's attorney, if he or she is represented, goes first. One or both parties or their respective attorneys may elect to waive making an opening statement. The petitioner's case. The petitioner or the petitioner attorney presents his or her case. For simplicity, we will just use the word petitioner. The petitioner presents evidence showing why the petitioner should get what he or she has requested in the divorce pleadings. The petitioner will call one or more witnesses to the stand and question them to obtain direct testimony that supports petitioner's position. Last, the petitioner may introduce physical evidence to support petitioner's position. Key witness. Normally in family law cases, the key witness for each side is the party themselves. Often the parties themselves are the only witnesses providing testimony for their respective case.